Good afternoon, everyone, and thank you for joining us once again for our technical session today. Today, we have with us Mr. Fareez Mohammed, who will be giving us a talk on occupational safety and on the Occupational Safety and Health Act 2004, amended 2006. Fareez Mohammed is a health and safety practitioner in the oil and gas industry, a lead HSC lecturer at MRK Company Limited, and an international occupational safety and health member. He is involved in many substantial projects over the years, for instance, the Sultansh Bachi Simas Library Birth to Rebuild, Chicago Bridge and Iron, Petrotrin Fluid Catalytic Cracking Unit Upgrade, the Offshore Drilling Company Soldado Field Project, and the Inter-Emergency Health, Safety and Security Consultants 20 Well Drilling Program, just to name a few. These were all crucial in the development of the professional he is today. Fareez is passionate about taking a hands-on approach to HSC, and his current position as a HSC officer at Touchstone Exploration Trinidad Limited allows him to do just that. There he is part of a dynamic team that is responsible for managing the company's HSC operations to meet international standards. This allows him to apply many of his professional HSC qualifications in oil and gas, rig, equipment inspection, well intervention safety, auditing, investigations, etc. Even with his extensive qualifications, Fareez has made a commitment to continuous professional development, as he believes that continuous improvement is impossible without continuous development. Being so deeply involved in the field of HSC, Fareez manifests his passion by sharing his wealth of knowledge and experience through his lectures. He believes that inspiring and empowering others would one day spark innovations that could incite positive change and indeed make the world a safer place. So without further ado, I'll hand over to Fareez so we can get started. Fareez, you can go ahead.
Thank you very much, Jonathan. A pleasant good afternoon to all. Thanks very much to AAPG and everyone who had granted me to fulfill this opportunity to do this presentation this afternoon. I have chosen a topic here on Occupational Safety and Health Act 2004 as amended in 2006, which is really the governing act for health and safety in Trinidad and Tobago. However, it covers a lot. It's a whole wealth of knowledge, but I extracted just the key points just to outline a full caption as to what the act covers and governs in Trinidad and Tobago. All right. So moving on, the main objective of the OSH Act, why it was really designed, is that the primary goal of this act is to reduce workplace hazards by implementing safety and health programs for both employers and their employees. The industries covered under this act, just to name a few, we have the industrial establishments, the agricultural establishments, construction sites, mining, educational institutions, protective services, hospitals, public and private health facilities, veterinary clinics, shops, and offices. The act itself, it comprises of 15 parts. And here we can see from part 1 to part 8. The first part covers the preliminary. Part 2 is the general duties of the OSH Act. Part 3 is the rights of employees to refuse work. Part 4 is safety. Part 5 covers fire. 6 is health. 7 is welfare. 8 is notification and investigation of accidents and industrial diseases. And 9 to 15 is employment of young persons, special application and extensions, special provisions, the OSH authority, the administration, this is actually the administration of the OSH authority. Part 14 it deals with offences, penalties, and legal proceedings. And part 15 is actually miscellaneous items and schedules of 1 and 2. So part 1, here we have provides a general application and interpretation of the Act, provides definition for the terminology used throughout the Act. For instance, the employer, a person who employs persons for the purpose of carrying out any trade, business, profession, office, vocation, or apprenticeship. A definition for the employee under the OSH Act is any person who has entered into or work under a contract with an employer or to do any skilled, unskilled, manual, clerical, or other work for hire or reward. And under the OSH Act, we have the occupier. The occupier is a person who has the ultimate control over the affairs of an industrial establishment. And in some cases, the occupier may also be the employer. Part 2 of the OSH Act, which is general duties. It outlines the general duties of each party involved. First, we're going to start with the duty of an employee. He must take reasonable care. He or she must take reasonable care for safety and health of themselves first and others who may be affected by his act or omission during the actual job task during working hours. He or she must cooperate with the employer in terms of compliance with the employer's duties and report to the employer breach of any acts or regulations. The employee must not interfere or misuse anything provided under the health, safety, and welfare, and must use PPE, protective devices, correctly. And PPE is a short abbreviation for personal protective equipment. And as we know, out in industry, we normally see employees wearing a head protection known as the safety hat, eye protection, which is known as safety glasses or goggles. We have hand protection, gloves. We have the full body protection, which is the coveralls, and then we have foot protection. Those are the common ones. The foot protection is those what we commonly call steel toe boots, right? All those things falls under the category of PPE or personal protective equipment, right? And it also outlines under the general duties that the employee must use these protective devices correctly, all right? Continuing with the general duties, we're moving on to the employer. The employer must prepare a safety policy providing he has 25 or more employees. If he does not, then he can just do a general statement that covers and governs the health and safety of his organization. The employer must conduct risk assessments, and we'll get a little bit further into that a little bit lower into the presentation. Prepare emergency plans, and this is for wherever his workplace, buildings, he has employees, as in case of any type of emergency, right, that employees are able to exit safely. Appoint a safety practitioner or practitioners depending on the volume of employees. So for every 25 employees, the OSH Act outlines that the employer must hire one safety practitioner, right? The employer must also ensure health, safety, and welfare of not only himself and the organization, but also to workers, third parties, clients, anyone that may be coming on board his facilities. Ensure HAZCOM and chemical safety plan. HAZCOM is short for hazardous communication, and a chemical safety plan will obviously outline to properly store your chemicals, to ensure that you have the right devices in case there's a chemical spill, if there's a chemical fire, how to treat it, and all these things falls under the chemical safety plan. Provide PPE, as said before, is personal protective equipment. So the employer must provide PPE, protective devices, etc., free of charge, or provide at half the value for those employed for 1 month or less. Okay, all these things must be done a written agreement or some form of agreement that can show in case, because we normally have employees saying that the employers don't provide the required PPE for the job. So this is where the employer must ensure that in distributing PPE towards his employees that they actually sign that they receive it, okay? Appointment, the employer must also appoint safety committees where he have 25 or more employees, and we'll get into what safety committee actually does a little bit later on, and to ensure the health and safety of the public is not affected by his work or activities. The general duties continue. This is for the occupiers to ensure safe conditions of premises, means of escape, ensure safe conditions of plant, equipment. The occupier must also ensure a written safety policy. The occupier must ensure a written emergency plan as outlined before by the employer. Same goes for the occupier. And the occupier must also ensure safety and health of self and that of others who may be affected. Here we have the general duties continuing with designers, manufacturers, importers, suppliers, etc. I included this slide here because, you know, in most cases, we have to depend on somebody to give us something that we may need within our organization, as small as it may be. We still need to purchase it from somebody, and that falls under manufacturers most of the time, right? So the general duties for designer, manufacturers, importers, suppliers, etc., they must ensure safety of machinery and plant. They must ensure and provide information for safe use. They must undertake research as from the designer and manufacturers to minimize risk from the operation. And whatever it is that they may buy, if it's a piece of equipment, they must install it in accordance to the installation procedures under the Health and Safety Act. All right? You don't want to erect or install something and it poses harm or injury to employees or even plant or equipment, as the case may be. All right? Part 3 of the OSH Act, it speaks of the right to refuse unsafe work. All right? This is misused and miscommunicated at times. So here it is. This is where the Act outlines exactly where the right to refuse unsafe work comes into play. So employees are empowered to protect themselves and can refuse unsafe work which can fall on a serious or imminent danger. This is an abbreviation. We have the IDLH, and that stands for immediately dangerous to your life and to your health. All right? So for example, let's just say that I am the owner, employer, or occupier of a manufacturing organization. And what I manufacture is furnitures. And during the manufacturing process, during working hours, there's constant dust being emitted, affecting the health and the well-being of all my employees, right? If an employee files a complaint and says, here's what's going on, his respiratory tract is being affected, right? And I choose not to take it up, then he can further report it to what we have here is the HSE committee or even the union, all right? Providing that he does not get any resolution or the actual issue is not being rectified or eliminated or control measures are not being put in place, he can now further take it to the OSH inspector, which is the last point that we have here. When notified, the OSH inspector investigates and decides within 24 hours from the time of refusal. There is a part of this Unsafe Act where the employer himself can also write the OSH inspector to investigate. That's providing that he for himself needs clarification on how to actually provide guidance to his organization to rectify the issue going forward, or to even see if the claim is being a legitimate claim from the employee, okay? Right to refuse unsafe work continues. The worker is protected from discipline, dismissal, reprisal, and refusing unsafe work, whether it is factual or not, whether this claim that he makes is factual or not. I, being the employer, I cannot discipline him or as you know, we use this other term, victimize our employees because, you know, they choose to refuse work, all right? So the law, the OSH Act itself protects these workers against all these little things that may happen, okay? The worker is deemed at work during the time of the refusal to the time the inspector makes a decision and therefore is entitled to regular payment. So even during, while the investigation is going on, before a decision is actually being made, right? The worker is deemed at work, whether the employer chooses to keep him at work or not. It is the employee is being deemed at work and must therefore be entitled to regular payment. All right. Aggrieved persons can appeal to the chief inspector. This is again provided that he does not get justice going through his health and safety committee or going through his management process there, and even you know, taking it up with a union. Right. He can further take it to a chief inspector. All right. The decision of the chief inspector can be appealed in an industrial court. Part 4 speaks of safety, employment of young persons, right? This is considered employees who is over the age of 18, but under the age of, over the age of 14, but under the age of 18 on dangerous machines. So this part of the Safety Act covers employees who is working in or around or with dangerous machineries. The person must be made aware of the dangers and the precautions to be observed. They must receive sufficient training. This must be provided by the employer, right? Or he must come with this training from what we would consider an accredited source, right? And must be supervised by a competent person at all times during the working hours and the work shift. So if the work shift is just 2 hours per day, he must be supervised and guided by a competent person throughout this entire work shift. All right, he must be provided with protective clothing and devices. He or she, person entering an area where they are likely to be exposed to risk for any bodily injury, shall be provided with suitable PPE, and again, that's personal protective equipment and instructions for use. So for example, with these young persons and them, or even new employees, when you hire them, in most cases, let's just say, for example, I use myself here. I was provided with a safety hat or a helmet. But the peak is to the front and it is designed to wear with the peak to the front. But however, if I was not trained in how to use the PPE the right way and I put it with the peak facing to the back, right? Then other employees or even the employer can now say I'm being a little bit stylish, you know, and not wearing the PPE appropriately. So this is where training for PPE must be, will come into play, especially for young persons, all right? No access to such area without PPE. So this is areas that is considered that the body would be exposed to any injury, as the case may be. And a notice to that effect shall be displayed. So this is where signs and notifications, and even on hiring, they must, all these things must be outlined to them before they actually start the job. Part 4, it speaks about removal of dust and fumes, right? Where exhaust appliances shall be provided and maintained as near as possible to the point of origin of the dust or fumes so as to prevent contamination of the air. Now, in most cases, we usually speak about, we make reference to with confined spaces, right? Confined spaces is already working in an area where the air is deficient, right? Meaning that is not meeting the acceptable oxygen level, meaning that there's flammability or even toxicity in the atmosphere itself within the work area, all right? But by using these exhaust appliances to help emit or discharge this toxic atmosphere, and then we use forced air ventilation to produce fresh air into the actual area. This is where this part of the OSH Act comes into play, all right? Effective safeguarding of machinery. So just in a nutshell, once there's a moving part, it must be guarded, right? It must be guarded in any form or fashion that you cannot conduct any mechanical work, repairs on it, or even if an employee goes to perform some test on the machinery, right, that he does not get caught or entangled in these moving parts, right? So that is where effective safeguarding of machinery comes into play. And then we have the health surveillance. So whereas we have employees who work in areas where the air quality can be affected, or even there's high noise levels, right? To help assist with this, the employer under the OSH Act must do something called like AAQM, or ambient air quality testing, right? To ensure that the pollution being emitted to the atmosphere, right, stays within acceptable limits, right? And where there's high noise levels, audiometric testing is required. Part 4 with safety continued under the OSH Act. We have the Health and Safety Committee, and this is where it is established between employer and employees where there are 25 or more employees. And the actual function of the Health and Safety Committee includes the review of the measures taken to ensure the safety and health of persons at the workplace, to investigate health and safety matters brought to the attention of the employer, and to attempt to resolve or dissolve these matters. And if it is unable to do so, it can now be referred to the Chief Inspector for his input for resolution, all right? The Chief Inspector is actually the person who oversees the OSH Act and the OSH agency. Part 5 speaks of fire. All establishments must be certified by a fire authority. In Trinidad and Tobago, here we have the TTFS, known as the Trinidad and Tobago Fire Service, right? That's our fire authority. So they must come in every 24 months, and the certificate should be made upon the inspection. A certificate will be given, provided that it is successful, that the establishment meets all the requirements that is required with the equipments and apparatus and devices to be outfitted in case there's a fire, for example, fire extinguishers, smoke detectors, heat detectors, right? The buildings or even the workplace, there must be means of escape and should be properly maintained and have no obstructions. Exits and routes must be highlighted. Part 6 of the Act. This is the health part of it. It speaks of cleanliness, where every industrial establishment shall be kept clean and free from unpleasant or harmful odor. Respiratory protection, where respiratory protection and approved standards shall be provided and maintained when necessary. So respiratory protection under the OSH Act is a very key thing because, for example, employees who work in a lab and there's a lot of toxic gases being emitted, and some employers, they don't understand that there is a standard and requirement of respiratory protection that must be met. And it must be bought from an approved source and provided to the employee to prevent them against these hazardous toxic gases coming out of the job being performed, right? And we have seen where inappropriate selection of respiratory protection being provided, and we have had claims and had to deal with it in the past, right? Under the health part as well, we have lighting, where there is unsuitable lighting. Suitable lighting shall be provided and maintained in every part of the establishment where employees are working or passing. Noise and vibration. Adequate steps should be taken to prevent hearing impairment caused by noise, health surveillance, PPE, etc. Overcrowding. An industrial establishment shall not be so overcrowded as to cause risk of injury to the health of persons being employed. So all this falls under access and egress, proper segregation, spacing out of the equipments. They actually test the emergency system to see if it's working, to ensure that in case of where you have a lot of employees in one area working, that they can all exit in case of any emergency properly without causing any risk to the employees or even to anyone that may be nearby. Ventilation. Adequate ventilation should be established either by a functioning air conditioning system or by the circulation of fresh air. Part 7 speaks of the welfare, where the employer must provide or occupier must provide drinking water. This is a convenient, sufficient supply of cool drinking water should be provided for all persons employed. And in some cases where employees actually have to use hot water, it must be provided as well. Washing facilities. This is to adequately clean and to easily accessible washing facilities with soap and hand drying materials or devices. All these things must be provided for employees. The sanitary part under the welfare, where clean and easily accessible sanitary conveniences should be provided and separate for men and women. And the welfare continues on to accommodation for clothing. This is where you would have appropriate change rooms with locks on the inside should be provided. We must also provide first aid supplies, fully equipped with first aid boxes or cupboards should be made available and updated regularly. So if every month there's an inspection that needs to take place with the first aid supplies and document the expiration date. When those medications have expired, you now need to contact the relevant disposal authority and have them take it out and just dispose of it in the regular general garbage waste, right? And then the first aid supplies that have been taken out must now be replenished so that you would always have a full supply of first aid appliances and equipment. Restrooms and lunchrooms, suitable area must be provided with adequate ventilation, lighting, and drinking water. And also, you must provide provision of rest areas for employees who may fall ill. Part 8 speaks of the notification and investigation of accidents and industrial diseases. In most cases, we always hear of investigation of accidents alone taking place, but the Act itself also governs and covers industrial diseases as well. Notification of accidents. If there's an accident which causes death or critical injury, the chief inspector should be informed within 48 hours of the accident. Now, when I say the chief inspector, you can also, he is the lead person or the manager of the OSH agency. But once you notify the OSH agency within this 48 hours, and you ensure that you get a reply from them, this would suffice in these instances. If there is an accident which did not result in critical injury, but require medical attention or prevented the employee from working, the chief inspector should be informed within 4 days. And that's the difference between critical injury and death. And if there is just a normal small accident that did not result in a critical injury. One is that the 48-hour period for the critical part of it, and then there is 4 working days that you must report this to the OSH agency, right? If it's not considered critical, all right? And they actually have a list that guides you when you go onto the OSH website as to what falls under critical and what falls under non-critical. Here we have preservation of the scene, where a person is killed or sustains a critical injury. Nothing at the scene should be tampered with except to save a life. So if it this basically means you need to preserve all the evidence there until the actual investigation is completed. Now, if it means that you have to go into the scene and actually rescue someone who is there, you are allowed under the Act to do so, with which is considered tampering of the evidence, right? Notification of occupational diseases. This is where we now need to notify the chief medical officer through the Occupational Safety and Health Agency, right, within 48 hours of the diagnosis. Where an autopsy is required, a district medical officer can arrange for an autopsy within 21 days of a death if he suspects death by work accident or occupational disease. So once there is something that transpired during the work shift that resulted in this death, right? The employer, the employee, his family members, legal action can be taken or even written to the district medical officer for an autopsy to be done to verify what the claim actually is, all right? Or what resulted in this actual death during the working hours. Part 9 speaks of employment of young workers. Before we spoke of young workers working with dangerous equipment and machineries, but here this part covers the hiring process of young persons. No young person, and again, this is young people who is considered over the age of 14 but under the age of 18 shall be employed to work in an industrial establishment for a period of 3 months or more, unless he or she is deemed fit to work by a medical practitioner. No young person shall be employed between the hours of 10 p.m. and 7 a.m. and should not work for more than 8 hours a day. All right, this is law under the OSH Act, right? Because those hours are considered high-risk hours, okay? Employers are required to maintain records of all young persons employed with all their details. And here we have parts 10 straight up until 13. Part 10 and 11 of the Act actually deals with special provisions, right? Where part 10 speaks of special application and extension. So for example, in my workplace, I would now like to store probably explosives, right? I would now need to make a special application through the OSH agency, right? And if needs be, I would now need to apply for extension if the application is probably not accepted within the time. Part 11 speaks of the special provisions. This is all the guidance in respect of the factories, buildings, operations, and works of engineering construction. So just to give a quick insight into this one, let's just say I need to do a modification on the place of employment, and I probably want to do some engineering construction on a building. For example, install an elevator to make access and egress easier or for emergency purposes, right? I now need to make this special application to the OSH agency, right? And they would give me the special provisions and guidance needed in order to do this. Part 12, under the OSH Act, right? The Occupational Safety and Health Authority was formed, giving them the power to enforce the Act. So in Part 12, the OSH Act itself tells you that we needed to form an Occupational Safety and Health Authority. And under the Act, it tells you that this authority was now given the power to enforce the same OSH Act. Okay? And Part 13 looks at the administrative issues relating to the Act. So, for example, this is, you know, where we'd have an organizational structure for any organization where we would have a manager, and then we would have officers and inspectors and underneath. This is where Part 13 actually looks at the administrative issues to help eliminate and guide out of these issues that may arise with the Act itself. Part 14, it speaks of offenses, and under offenses, there's breaches of the Act, regulations, etc. There's non-compliance with any prohibitions, restrictions, etc. False entries in a register, making false statements, obstructing an inspector, and pretending to be an inspector. All these things are actual lawful offenses under the OSH Act. All right. And yes, we have had what we would say citizens pretending to be inspectors, right, of the OSH agency. So please ensure that whoever it is that comes onto your organization, before you grant them permission, you do some verification and some background check before you actually allow them into your workplace for any inspection. Okay. Moving on to prosecution, breaches of the Act can constitute criminal action where an inspector citation was disregarded by the employer. So for example, this is where an actual inspector from the OSH agency comes into your workplace and he has found that you were in violation or found that I was in violation of one of the acts where I was not providing a safe and health workplace for my employees, right? They can now give me a citation based on that and tell me, hey, Fareez, you now need to rectify this in probably a week time, all right? And upon re-inspection, if they realize that I did not rectify what the citation has outlined, they can now take me to court where I can be charged under the Criminal Act in the industrial court. And then we have the civil action. This is where an employee can take his or her employer to court for failure of provision according to the OSH Act. So all these governing rules and regulations that we have here in the OSH Act that is made law, if I am an employer and I have an employee, and again, I did not provide them, let's just say probably with PPE, right? What I probably have is a lab facility where they mix chemicals, and I did not provide them with hand protection and proper ventilation and respiratory protection and even eye protection where their eyes can be affected by splashing of the chemical. They now can take me to court and even report me to the OSH agency, right? And this is where this matter, when it goes to court between employer and employee, I can now be charged being the employer under the civil action of the OSH Act. Continuing with part 14, we have offenses, penalties, and legal proceedings continuing here. We have the penalties where the fines can range anywhere between $2,000 up to $100,000. This is dependent on the what we would say the intensity of the breach itself, right? It can result in imprisonment for up to 3 months, all the way up until 3 years. And in some instances, you can even, where both imprisonment and penalties can be applied for violations or breaches of the Act. Part 15 of the OSH Act, which is actually the last part. This is the miscellaneous items and schedules of 1 and 2 with the list of occupational diseases and the Occupational Safety and Health Authority rules, where it says educating the roles and responsibilities of the government of Trinidad and Tobago. Their main duty is to educate the public of this OSH Act. They must also educate workers and entrepreneurs about the OSH Act, right? In whatever form or fashion they need to get this OSH Act ruled out and get it across to the general public, the citizens. They need to do so if it's via emails, notifications, daily newspapers. If it means that they have to do it via the mailing system, they need to do this. That's one of the key roles and responsibilities of the government. They also have to upgrade, this is upgrading and strengthening the enforcement agency by providing appropriate training for safety officers and other responsible persons. They must also, the government of Trinidad and Tobago, providing a proper legal framework to deal with matters for the industrial court with all these legal claims that would normally happen through the OSH Act, and also compiling relevant statistics to be used to measure and to evaluate the success of the OSH Act and amend accordingly. All right, and this is where we have seen where it was amended once the OSH Act was actually implemented and ruled out and came into enforcement in 2004. But after careful review of 2 years, it was amended in 2006. All right. And that brings me to the end of the presentation here this afternoon. And I now leave room for any questions that you all may have based on the presentation and the OSH Act of Trinidad and Tobago.
Hey, thank you, Fareez. That's a really informative presentation. Thanks again. We do have a couple of questions. Could start with this one, I guess. For someone who's looking to get into health and safety, what is a good starting point for them to begin?
So normally I would advise that they do what is known as general OSHA construction, and OSHA general industry. This is the 30-hour programs that is usually given. It gives you a proper foundation into all the different key areas there is in health and safety. For example, working at heights, confined space, fire safety, right? Just to name a few. From there, you could move on to probably applying into, let's just say, a first aid course that would complement the safety background very well.
Okay, thanks. Thanks for that answer. Okay, here's one. Do HSE regulations vary from company to company or country to country, or is there a set, or are all the regulations set for each company and country?
Okay, so to answer the first part of the question, because the question is in two parts. Each country has their own laws, right? And they also have their own, what we would say, their own safety laws and regulations that govern their organization, sorry, their country. For companies on the whole, wherever the company establishment is, for example, like I am speaking of Trinidad and Tobago, right? Once we have an establishment, or I decide to open up an establishment here in Trinidad and Tobago, I must comply with the safety laws of Trinidad and Tobago. So I hope that answers the question. Or I could even go so far to say, if I choose to go to America or even the UK, the American safety regulations and laws and the UK health and safety regulations and laws, both of them are different and even different to Trinidad and Tobago. So wherever you go to, whichever part of the world, and you choose to open up an organization, you must comply. This is one of the laws you must comply with.
Okay, thanks a lot. One person asked about the regulations that are in place for offshore rigs and offshore drilling. If you could just touch on that.
Yeah, so that is governed under by something else called the drilling regulations of Trinidad and Tobago. So that is something that's an entirely different law and act away from the actual Health and Safety Act of Trinidad and Tobago. So that is what you would know, that person or whoever is asking the question, we would probably, I can do that on another presentation.
Okay, no problem.
Yes.
Thanks. We have one more. How much training does one need to be an HSE officer?
Now, this depends. This varies a lot because they are very small organizations and they don't require you with a lot of technicalities. But then there are the larger establishments. For example, I don't really like to use company names, but you know, we are familiar with BP and BHP and so forth. You know, you would now need to ensure that you go the full 9 yards with, you know, getting yourself prepared and knowledgeable with the right safety and health laws, not only of Trinidad and Tobago, but also throughout the world, because these are actually international companies, you know, and in order to meet the demanding requests of these jobs that are outside there, that is what would actually set the benchmarker for you to say how qualified you actually need to be as a health and safety practitioner.
Okay, thank you. What is the difference between STOW certification and OSHA in general?
Okay, so STOW certification, well, OSHA, like I said, this entire OSH Act is actually the law that governs the health and safety of Trinidad and Tobago. STOW, however, is what we would call like an auditing body to ensure that companies comply with the safety management system of the OSH Act.
Okay. Okay. All right. I think that's it for the questions.
Okay.
So, on behalf of the APG Young Professionals Trinidad and Tobago chapter, Fareez, we'd like to thank you for giving us this presentation. It's a very enlightening one. And I'm sure everyone that's viewing on the Zoom call and as well on Facebook Live, that we all learned a lot from you today. And thank you once again, and we hope to work with you again in future if possible.
Thanks very much, and thanks very much to the entire organization of EAPG for granting me this opportunity. I hope it was a very fruitful and learning experience for each and everyone. All right, thanks.
Thank you, Fareez.
Thanks.